And now we are moving from Copenhagen to The Hague. I am delighted to introduce a colleague of ours, Dr. Predrag Dojčinović, who is now an adjunct faculty member at the University of Connecticut. But before he got that position, he spent more than 20 years in The Hague, working for the International War Crime Tribunal, specifically on the Serbian trials. So if you want to meet somebody who met and talked to Milosevic many a time, that would be Predrag Dojčinović. So Predrag, please tell us a little bit more about what the International War Crime Tribunals are like and what the language issues are there.
Thank you, Aneta, for this wonderful introduction. I have only one correction. I have never met Milosevic in person. I have seen him in the courtroom where I sat on a number of occasions, but never had that, I almost said pleasure, opportunity to meet him. I met many others for good or bad reasons, of course. Well, today, I suppose I'm facing really a very serious challenge, because after 20 years in practice in international criminal trials, justice, and 70 years of jurisprudence, more or less, that I would like to cover, all I can do is stay on the surface and offer you just a very few highlights of the cases related and moments over the past 70 years, if you like, related to the topic of my talk: language as evidence in international criminal trials. So maybe the best way to begin is to say that based on a really rather comprehensive research in cognitive and social sciences with the humanities, recent history quite clearly shows, I believe, that linguistic evidence played the key role in all international armed conflicts. And so a comparative research to the historical situations, obviously, of Nazi Germany, Rwanda, and Yugoslavia, because we had 3 war crimes tribunals, the IMT, the ICTR, and ICTY. In fact, along with a number of non-international trials, of course, and cases that were tried not only in these countries but elsewhere as well. So all of them together, I think they offer a lot of, they offer a plethora of examples of linguistic and particularly culture-specific and culture-determined types of evidence that were employed by mainly prosecutors in all phases of the preparation and execution of the mass atrocity crimes. Mass atrocity crimes is an umbrella term for genocide, crimes against humanity, and war crimes for non-lawyers. And so the question, in fact, arises if we go back, like I said, almost 70 years, I suppose, to 1945-46. Excuse me if I got the numbers wrong. How some of this historical material may have, in fact, initially been reflected at the IMT at Nuremberg in 1945 and 46. So at Nuremberg, the first major propaganda and language-based trial was in international law was the case of Julius Streicher. You probably, or most of you, are familiar with that case. Julius Streicher was one of the Nazis on trial in Nuremberg. He was the editor and owner of the perhaps most infamous Nazi propaganda publication, Der Stürmer. And the prosecution, upon his arrest, decided to investigate deeper into the relevance and meaning of this publication and Streicher's role in the content of the publication, as well as his contacts with other Nazis within the network, right? And so I wish I had more time to go into the investigative aspect of this case, because it's fascinating to learn, and I read some of the memos and correspondence within the prosecution team, how they struggled with this particular investigation. And finally, they sort of settled the issue, generally speaking, that Streicher's propaganda was simply anti-Semitic propaganda as words or words used as persecution. So when the trial began on November 14, Streicher was indicted on 2 charges: common plan or conspiracy, and more importantly, crimes against humanity. So the prosecution was particularly interested in persecution on political, racial, and religious grounds as a crime against humanity, of course. Most importantly, there was one word, a single word, that was positioned sort of at the center of this legal framework. That was the word Jew. Virtually all documents and exhibits that were submitted, tendered into evidence by the prosecution had that word, and there were hundreds of exhibits that were tendered by the prosecution in the course of the trial. So let us have just a quick look at some of the exhibits introduced by the prosecutor. You will clearly see that the word Jew features very prominently in all of these exhibits, and the content of all these exhibits obviously were all related to the main charges, that is persecution as a crime against humanity. And I'm not going to go into legal discussion now and explain or try to explain why. What's interesting is that this is the first trial, like I said, propaganda and language-based trial in international criminal justice. It was called the first propaganda trial and trial by words or through words. That was uttered several times. Well, I hope you can see some of the highlights and read clearly, because I can see them from my from this position. But one can say that this same or similar linguistic trend has sort of continued to manifest itself after the IMT at Nuremberg in virtually all mass atrocity situations since the Second World War. I'm showing you here the judgment, which is something you don't need to see. He was, convicted of a crime against humanity and acquitted of the first charge. And so, again, you see how the judges approached the evidence. This is just a brief excerpt from the judgment to Streicher, which was about page and a half long. It is a fascinating case because there are so many flaws in that judgment and in that case, regardless of what I may or may not think about Streicher himself, that there has been a body of scholarly work analyzing only that. And that is unfortunately, many of these issues were taken over subsequently by other tribunals and courts as part of the international jurisprudence, of course. So here we have the next situation, which is comparable, the Rwandan situation that we are all familiar with because we were still there when it was actually unfolding. And so one can say that, in fact, that the response, in my opinion, to this newly emerging evidence, the linguistic type of evidence, and this is, in legal terms, the evidence, in fact, of mens rea, guilty mind, right? There is a whole variety there in subcategories. has been more substantial in Rwandan cases than in any other case before or after, since. So one of the most telling examples, and I've deliberately selected an example which wasn't tried by the Rwandan tribunal, but it played an important role within a greater context of the Rwandan trial, is the case of Leon Mugesera, who is an academic and a historian who was very close to the then later late President Habyarimana in Rwanda. And Mugesera in November, specifically November 1992, excuse me, he gave a speech right there. There is a little church up on the hill where he stood and gave one of the most famous speeches given, interestingly enough, about a year and a half prior to the outbreak of genocide in Rwanda. And this has been studied by many scholars. For instance, Mugesera fled after the speech to Canada. In 2001, he was a group of human rights lawyers were seeking his extradition to Rwanda, and that did not go well immediately. Later on, he was extradited and tried properly for incitement to commit genocide in Rwanda in 2013 and 16, and now he's serving a life prison sentence in Rwanda. However, all I can do here is I can show you bits and pieces from that infamous speech that can be found on the internet even now. I believe there are a couple of different versions, but they're not significantly different. So if you look at these words and phrases around, you will notice that right, what do they say? In legal terms, there is a lot of hate speech. There is a lot of like vermin dehumanizing type of speech. But there is something, and pretty straightforward speech, like he ended his talk there in front of, there were several hundred villagers, I believe. Know that the person whose throat you do not cut now will be the one who will cut yours. It is a pretty straightforward statement by the speaker. What I'm interested in here are the words that he used, such as inyenzi and inkuntani. And this is, that belongs to the body of evidence that we now refer to, and if I may take a little credit for that, as indirect speech references to, in this case, the victims, the Tutsi, because we use the same model at the ICTY in our research and analytical work. So just try to imagine a courtroom, these two words, and many other, as a matter of fact, I'm just focusing on these two, played very important role throughout Rwandan trials at the ICTR and and all other trials. So just try to imagine judges and parties coming from all over the world to put on trial one gentleman there who uses some words in his speech that no one understands. And yet they all have an impression that it's something incredibly important in it. So what do the prosecutors do? The defense, of course, always objects to these kinds of evidence, linguistic evidence. And the judges, they call expert witnesses. In this case, they first called a very well-known American historian of Africa, Alison DeForge, who, by the way, testified in the Canadian case in 2001 as well. What Alison DeForge did, she simply analyzed the speech as a historian and the speaker of Kinyarwanda as well. And so she explained a number of these terms, so you can see some of her explanations from her expert report and her testimony here. However, I don't think I need to. I hope you can read some of this, just roughly speaking, just to see that the first word, for instance, has historical connotations. So the judges obviously want to know what these connotations are, how the génocidaire, how the perpetrators may have understood this term, or the next term in Yenzi, which basically means cockroaches, but the word, as we will learn in a moment, has been evolving over time, and particularly during the relevant period, the genocidal period. So what happened was, and that was one of the most important moments, I believe, for all of the trials in Rwanda, the prosecution called an incredibly modest man, a sociolinguist born in Rwanda, Dr. Matthias Ruzindana, who I would recommend warmly to you as a guest, who was called to analyze and contextualize a set of words, a set of words that were used by the génocidaire to communicate their messages. And here is part of his explanation. Again, you can have a quick look. He explains what the word means, how it evolved, and how it may have affected the perpetrators and eventually the victims, the Tutsi. So here is, as a result of his testimony in the first trial, Akayesu trial, how the judges thought about his. It was the turning point of the linguistic evidence altogether in international criminal trials, I believe. They simply said they relied substantially on the testimony of Dr. Matthias Ruzindana, an expert witness of linguistics, for its understanding of these terms. In other words, without socio-linguistic interpretation and also historical, the judges would not have understood part of the lexicon and terminology used by the perpetrators to communicate messages as to what should be done and to whom and where. So an important part of that we cannot deal with at this moment is that Matthias Ruzindana, of course, is Rwandan born. So what Alison Deforge could not have understood, regardless of her knowledge of the local language, Ruzindana understood instinctively, immediately, because he was a passive learner, right? He spoke the language. It was part of, if I can use this fancy word, part of his body. It's part of the linguistic studies now, cognitive linguistic studies. So he conveyed the meanings, but above and beyond it, the resonances of these meanings and their impact on the minds of the perpetrators. So how is this important? One of our old judges, late Antonio Cassese, immediately noted in one of his publications, at a textbook on international criminal law, that even implicit messages or utterances may amount to incitement, right? As long as the addressees immediately grasp the implications of the message in light of its cultural and linguistic content. Recently, a younger scholar summed it all up quite conveniently, saying a direct appeal for genocide may therefore be implicit. And that is very important, and that was precisely the role of these experts that I mentioned, that there were many other experts, including defense experts in this case. So just briefly, let me move on to where I spent behind these walls about 20 years. So I'll spend now 2 minutes dealing with this. Well, perhaps one of the best examples of the similar indirect speech references to the victims, just like in Rwandan cases, was the case of Goran Jelisic, one of the early trials. I had an opportunity to interview these gentlemen on several occasions. You can see some of the exhibits there. Jelisic is wearing a blue shirt. He was a reserve policeman in the town of Brčko in '92 in Bosnia. Taking 2 Muslims for execution. Other exhibits after that, it was a photo shoot actually shot step by step the execution, so I want to spare you these gruesome images. So I'm stopping here when he's walking them down the street to kill them. He told us during these interviews that he couldn't have his morning cup of coffee before he killed at least 1 or 2 Muslims. He identified himself to his victims as Serbian Adolf, and he referred to them as Turks and Balijas. Unfortunately, both these terms that are loaded with meaning and resonances, just like many of the similar terms in Rwanda were never really properly explained and contextualized by witnesses, let alone expert witnesses and linguists, so that he was in the first instance acquitted of genocide, which was one of the first genocide cases that we had there. So I believe that we should have called linguists, particularly a cognitive linguist, to explain to the judges what the references Turks and Balijas in the local language may have meant under the specific conditions, and what their impact may have been on his actions, intent and actions, if you like. So here is how the translation unit just briefly explained, and this is an excellent publication coming from my former colleague from the translation unit at the ICTY on the way in which they approached translation of such terms. They have very limited scope. They can only provide one meaning, and occasionally, and that was an agreement that was adjudicated, they could, the official translation unit can say that a term is a derogatory term, and this is where they have to stop. And then the parties would obviously argue as to the relevance of this commentary in the parentheses by the translation unit. So here is how this author explains the word Balija. And indeed, in one of the great genocide cases, General Krstić, who testified in his own defense, denied ever using it. It's very interesting. You can have a look. There is a link there to his testimony where he is trying to deny that he's ever used this, this word in his life, let alone during the relevant genocidal period in Srebrenica. Yes, I'm getting there. So here is again the same thing from Ellen Elias Bursac. I'm sorry, I forgot to mention her name. How the translation unit had formulated its policy in regard to these terms. But that would not have been enough and would never be enough. You always have to call an expert witness and fact witnesses and hopefully insiders, as we always did in other witnesses. Now I'm going to stop here when the things really get interesting, and I'll just because I'm getting a yellow card there. I spent several years working on the very last case at the ICTY. In this case, my job and the job of my research and analytical team was solely based on the identification of persecutory and genocidal intent in the utterances of General Ratko Mladić and his associates. So we spent over 2 years more or less building a database for the prosecution case against him and many of his associates. That had significantly, for the first time in the history of the tribunal, affected the approach to witnesses, prosecution and defense witnesses, by the prosecution. We introduced a number of generic questions that were asked whether we had a prosecution or a defense witness along these lines, focusing on particularly the words and phrases that we identified in our database. The results were amazing. The responses were just the best evidence one could think of, I believe. And whether we've succeeded or not is yet to be seen in November when the judgment is coming out. The trial judgment is going to be appeal judgment, certainly. in due course. So whether we have succeeded in our work, we'll find out by the end of the year. So thank you very much.
Introduce the team that has been instrumental in putting together this conference. Andre, Nina, Malena. The best thing I could do is to keep away and not get in their way, and everything will run smoothly. So please, questions. If you don't get to ask your question, we'll get back to this in the discussion period. Intimidate everybody into a very quick question.
I said to Annetta before I started, it would take a course, at least one, to go into details and explain all the minute issues that we were facing over the past several years.
When I said that, we will consider it, right?
Well, I didn't want to suggest it.
Can you explain a little more exactly how it worked? When were these interpreters that were calling an item derogatory? So if I'm speaking a translation, I'm going along and saying, he said, or I don't say he says, but I'm giving his speech. Yeah. He says the people were derogatory word. Is that how it works?
They would, at some point, I wouldn't know when anymore, and that became an adjudicated fact, as it's called. There was an agreement between the translation service, only the translation service would know when exactly, and the chambers, the judges that is, to allow the translation service to use an explanation, additional explanation as to the meaning of a specific word in the parentheses. My understanding, and I worked for the Office of the Prosecutor, not for the translation unit, so I wouldn't know exactly how they operated over there. But my understanding is, based on the documents that I read, they would insert this interpretation of the meaning of the word into their official translation of documents into English, French, and other languages sometimes. And my understanding, again, is that this interpretation comes from the most authoritative dictionaries. So it's plain and simple, a dictionary from the shelf. And here is what it says. The word balia is a derogatory term and is a reference to the Muslim people there, etc., etc. So that would be there in the parentheses. However, that can, of course, always be disputed, as it was, always has been, by particularly the defense. The defense always tries to say, well, look, this is not the only meaning of the word, because some of these words are real polysemic. They have different meanings. Some of them are even difficult to grasp, often, even for the local speakers, so you need a particular context. We had one other word was in Serbian, Bosnian, Croatian, and other languages. There is čišćenje, which means cleaning or cleansing or mopping up or sweeping. And so you see the whole range of possibilities here. So, of course, as a prosecutor, I would say, well, it's cleansing, meaning it's an ethnic cleansing that was going on in this area, whereas the defense attorney would say, no, 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 it is a legitimate military operation conducted by a local police or military unit, and it was mopping up or sweeping of the... So this particular word, it was decided in one of the cases, the Krajišnik case, that it would always stay in its original in the transcripts, and it would always be contextualized on a case-to-case basis. As the documents would come along, we want to introduce a document, a witness would discuss the document, the word would be contextualized based on that document, and not some general understanding of what the word might mean. So for researchers and research purposes, people who want to look that up in official transcripts, they have to type in čišćenje and not cleansing or cleaning or sweeping or mopping up or whatever it might mean. So there is a distinction between the translation unit and the prosecutorial and defense approach to any one of these terms. What is more interesting is when you want to build your evidence upon a word. And that is not just to call an expert witness to explain the word, but then you call the perpetrators, because you first interview them, then they assign their statements, then you call them to testify, often in different categories of witnesses, and then they contextualize the evidence. And this is why General Krstić fought so much to say, I never use the word Balija. I never use, because in Srebrenica in July 1995, every reference to Balija was a reference generalizing the entire civilian population of Srebrenica, as it was used historically even before, as a derogatory term, before the outbreak of the war. He knew, I guess he was advised by his lawyers, that would have been an addition to his mens rea in terms of genocidal intent. It would have sentenced him, which it did initially, but then it was overturned, which is another discussion then. So he was acquitted of genocide and sentenced for aiding and abetting genocide. And language played a very important role in this judgment.
Thank you very much, Predrag.
Thank you.
So as you can see, sometimes in a conference 20 minutes can be way too long, and sometimes 20 minutes is just not enough to hear an interesting story. But we are not leaving the international trials just yet. Now we will hear about the same context from the perspective of a lawyer and turn our lens on another way of looking and thinking about language in court, and that is interpreting. I am very happy to introduce my colleague from the University of Greenwich, Dragana Spencer.
Sorry, I just need to find my slides.
Should be in the folder here. Which one is yours? This one?
No. Oh my God, it isn't the wrong thing.
I think it's a PDF. Well, it's probably. So we're just going to take a minute to bring up the other presentation, because we can't get this to work.
Go into my email. Can that work? Because I copied it to myself.
Yes.
Don't go. Don't go. Sorry? No, it's me.
Do you have anything more on that? Or something related? Yeah.
Come on, back.
So just click look på. This is fine, by the way. I mean, this happens.
Where is the at? Oh, this is me panicking now.
Don't panic, it's fine. Yeah,
Go down.
probably just have to use the scroll bar on
Thank you very much. Sorry about the delay, a slight glitch with my slides. So as Annette said, I will try and offer a slightly different perspective on the use of language in international criminal proceedings, and the purpose of this to look at them from the point of view of defense and those who actually are suspected, accused and indicted for war crimes. So in particular, I'm looking at the right to
this one and back one is that one. So
it's just getting read up.
So back and forth.
Okay. Look at the right to interpretation and translation services in the international criminal courts, mainly the Tribunal for Yugoslavia and Rwanda, that Predak talked about, and in particular the International Criminal Court, now the Permanent International Criminal Court. And the reason I will be focusing on the ICC is because it is supposed to consolidate and elevate the standards which relate to access to language rights, translation, interpretation in international criminal proceedings. So I'll be giving you examples of how the ICC has been dealing so far with these issues, and with the view of trying to understand how the standard established at the international level inform domestic jurisdictions and the domestic processes which relate to in police investigations and arrests. So I start by giving examples from one of the two most recent cases from the ICC. The ICC is still in its infancy. It has only completed 2 cases. And in 2011, the accused spoke a language he did not understand. The language of the courts, the working languages of the court, which were English and French, and he wanted to speak in his own native language, which was Zagava. This particular language presented the ICC with a great difficulty because it is an uncodified language. It consists of only 5,000 words, and so the ICC was really struggling to find somebody who can interpret it at an adequate and competent level for the purposes of the proceedings before the International Criminal Court. And so the ICC registry estimated it would take 30 months to find somebody to translate the relevant documents so that the accused will be informed of the charges against them. You don't have to be lawyers, and I have tried to dilute this as much as possible, make it as accessible as possible. But what it means is that if you ever get arrested, one of your fundamental rights is that you be informed of the charges promptly. In some cases, that is within 48 hours. In some instances, 7 days, 14 days. The maximum across some European jurisdiction is 28 days. 30 months seems excessive and disproportionate. So the first thing to see is that the access to language services, or lack of them, in this particular case, resulted in the damage to 2 very important and very fundamental rights, and that is the right to be informed of charges promptly. And there is also a right that if one is arrested and taken to a tribunal, that the proceedings should be expeditious. They have to start and they have to conclude in a timely fashion. In another case, in Lubanga case, the International Criminal Court reviewed its practices and the quality of its languages services, and in a document which for years was confidential, they reported that they were not really happy with the quality of interpretation and translation within the court. And so ICC documents revealed that the rotation of 4 interpreters during trial was disruptive and detrimental to the quality of proceedings. And they also acknowledged that because of the shortages of qualified interpreters, French interpreters were frequently working in English booths, and that really, really shouldn't be happening. We are talking about multilingual, multicultural settings. And so when French interpreters sit in English booths, you have problems. As a defendant, you would be concerned about this because the French grammatically and lexically and stylistically have a different approach to interpretation to the English one. So Many lexical, grammatical, and paralinguistic errors were identified as a result of that. It meant that the interpretations were inconsistent, and that raised serious questions for the ICC. The other problem that was recently identified in the ICC is that because they're dealing with, as opposed to the Yugoslavian tribunal, as opposed to the Rwandan tribunal, the ICC has jurisdiction to adjudicate and hear cases in situations from all over the world. So they have to have capacity to interpret, they have to have the capacity and language services that can deal with a multiplicity of languages and cultures. So the ICC employed freelance interpreters, particularly in pre-trial stages, whose overall quality of interpretation did not match that of court interpreters. And so these freelance interpreters did not enjoy the same type of contracts as the conference interpreters that sit in international criminal tribunals and enjoy. So that is kind of a very brief outline of the recent problems that the International Criminal Court has faced. I'm now moving to three very, very important and very, very basic documents which provide for the right to competent language services. And this requirement that the language services provide competent interpretation and translation is very, very closely and fundamentally linked to the right of the defendant to participate in his or her proceedings in a meaningful way. So the European Convention of Human Rights of 1950 states that there is a right to free interpretation if the accused cannot understand or speak the language used in a court. So we're talking about official court languages. These are normally English and French. The International Covenant on Civic and Political Rights provides that a person has a right to be promptly and in detail informed of the nature and cause of the charges in a language that the accused understands, but not necessarily speaks. So we are seeing the two main international law human rights provisions differ as to what standards should be used. And the Human Rights Committee General Comment 2007, this is one of the most authoritative comments that we have on the interpretation of international human rights provisions, gives something on one hand and takes something on the other. So in the first place, the General Comment number 32 states that foreign nationals whose mother tongue differs from the official court languages are in principles not entitled to free assistance of an interpreter if they know the language sufficiently to defend themselves effectively. So if you know the language a little bit, the presumption is you're probably going to be capable of defending yourselves. And that, in some cases, has been disputed significantly. How does the court assess the competency of a defendant in order to determine whether they need the assistance of interpreters and translations in order to defend themselves effectively? And a little bit worryingly, the same document states that if the accused does not understand the language used in the court, procedural rights to fairness may be satisfied if relevant documents may be available to them, to their counsel who is familiar with the official language. So the requirement here is that neither the accused nor their counsel have full competence in one of the languages used by the court. There are numerous other provisions that deal with language rights, but these are these two documents outline the main fundamental rights that international courts should be upholding. And this leads me again to the jurisprudence of the International Criminal Court in a more recent case. This is the Katanga case. And here we had an accused who spoke some French, and the prosecution argued that his competence in French was perfectly adequate for him to understand proceedings and defend himself. And he argued that although he was able to speak some French, in order to participate effectively in defending himself, he he should have been afforded competent interpretation and translation by the court. And so this is the first time that the ICC and any court at this level has actually acknowledged that given the gravity of the crime that these accused are charged with, and given the enormous complexity in a multicultural and multilingual courtroom settings where the judges come from all over the world, the interpreters come from all over the world, the languages spoken are not just one or two, the ICC acknowledged that the relevant standard used in determining the level of language proficiency and understanding of the accused must be higher, for example, than that applicable to the European Convention of Human Rights or the International Covenant on Civil and Political Rights. This is the first time the International Criminal Court is trying to elevate the right of languages for the accused facing these charges. And so we have the international documents, which the European Convention of Human Rights and the International Covenant on Civil and Political Rights, outlining the basic rights. What we then have are the different statutes of international courts or tribunals. And what is interesting is there is no uniformity here. Every statute comes with a different standard for this. So at the ICC, the accused is entitled to free language services if they do not fully both speak and understand either of the working languages of the court, that is English or French, and that if they don't fully speak either of these languages, the interpretation they're given must be competent. And that is the first time that an international legal document refers to the fact that interpretation for the purposes of the trial has to be competent. The ICTY and ICTR statute, that's the Tribunal for Yugoslavia and Rwanda, have the same provision, but they do not require the interpretation to be competent. They do not specifically make a requirement that interpretation needs to be competent. The Special Court for Sierra Leone offers free assistance if the accused cannot understand and speak the language used in the court, so a vaguer and more standard definition. And the East Timor panels actually don't have any provisions for overseas defendants. So what does that mean generally? Now that we have the jurisprudence from the ICC, we derive, I think, a clear right to seek and expect, to have legitimate expectations from international and hybrid courts and tribunals to provide both competent and effective language services. What does that mean? It means that at a minimum, there should exist in law an explicit right, a corresponding right to review of translated transcripts and other documents. This is done routinely in all courts and tribunals. But what the courts do, they try to, and they have some legitimate reasons for doing that, which is mostly time and money, they restrict the type of documents that need to be translated for the accused. And that leads to a big question. No decision has ever been overturned at the international level because there has been bad interpretation or translation. And one of the reasons for that, well, in the first place, is because the nature of the crime that the people sitting in international courts are faced with. There is a strong presumption about their guilt, and I think this is what Tanya was talking about at the very beginning. These are high-profile cases, and there is no smoke without fire. There is a huge public incentive and expectations that the international criminal courts will achieve a high rate of conviction. And so language rights are considered to be subordinate to all other rights, and in terms of remedies, no decision has so far been vitiated, annulled. The only remedies that we have seen is a mitigation of sentence in extreme cases. The reason for that, one is that, as I said, language rights are still not considered to be fundamental rights. They're considered to be secondary rights, and certainly subordinate to the overall interest of justice to prosecute people within these trials. And also because, and this is where we needed the help of, lawyers need the help of linguists, and as it was said at the beginning, we need to talk about this in an interdisciplinary way. How do we quantify the damage caused through bad interpretation and translation? Thank you. So what is the role of international judgment or of international judges? Well, international law very, very clearly says that it is the role of the courts and therefore the judges to ensure that the defendant has right to effective language services. However, the ICTY, which provided the most jurisprudence for the other courts and the International Criminal Court as well, created a code, the ICTY Code for Interpreters and Translators, which states that interpreters and translators shall only accept assignments that they are competent to perform. And from a defense point of view, from a legal point of view, that appears to be a delegation of the duty of the court. It is the job of the judges to have the relevant skill and expertise to monitor what the translators and interpreters are doing and weigh the accuracy of their work in the same way as they would do with any other expert witness. So the most problematic and crucial thing that I'm trying to highlight here is this delegation of duties on part of the judges, which is very different from what judges do at a domestic level. So the Office of the Prosecutor of the ICTY frequently outsource translators to non-qualified staff such as data entry clerks. Why is all of this relevant? It is relevant because as an accused, when the ICC or any other international criminal court issues an arrest warrant against you, for instance, there is an expectation in law that all the proceedings against you, including police interviewing, including the questioning of victims, witnesses, etc., is done at the same, with the same care and at the same standard from the beginning of the investigation all the way to the end of trial proceedings. So when the ICC accuses somebody, they have a huge team of people. They go to Sudan, the Democratic Republic of Congo, and they employ local interpreters who are not trained like the simultaneous interpreters that the ICC and other courts employ. And so there is a great disparity in the quality of those language services. In the ICTY, in the Mučić case, the tribunal established a rule, which is also a very peculiar feature of international criminal law, that the interpreter is not responsible for the authentication of their work. So all the translations are sealed, anonymized, and the international criminal law makes sure that translators cannot be compelled as witnesses to proceedings. The reasoning, according to the ICTY, is that it will be procedurally undesirable to involve them in a conflict between parties. And that is very, very different from what happens at a domestic level, so clear departure from well-established both common law and civil law procedures. Now, the problem with the ICC, and I will conclude, I've been given the yellow card, I'm wrapping all of this up, is there are some practical problems here, and that is because at the ICC we have 18 judges, the working languages are English and French, and the judges don't really have to go through any proper accreditation. They're not actually tested in their proficiency of languages. So when they apply for the job, they fill in a form, and of the 18 judges, only 3 describe English as the mother tongue primary language, and they themselves come up with these attributes: good, fluent, and excellent. The knowledge of French is not mandatory, and again, judges accept that they have no knowledge of the language. Some have rusty knowledge of French writing skills. Some say they have limited knowledge, and others that have intermediate. And I think this creates a little bit of a chaos. So you have the judges who are not fully competent in the working languages of the court, defendants who may not be, who may not fully speak the working of the court, and then interpreters and translators who may not be competent. I have to finish here, but if you have any questions, I'll happily answer them. Thank you. 20 minutes is just not enough. I think we all agree on that.
Yes, so
yeah.
Open for questions, and I will ask Dragana to maybe take one of the other mics, and Andre, could you please maybe help me to connect with our next speaker who will be talking to us from afar.
Oh, okay.
Thank you.
Do these work? Either one. No, either one.